In this session, we're jumping into one of the most useful and occasionally most dramatic topics in tort law, occupier's liability. Now, if you've ever tripped over a cracked paving stone outside a shop, or wondered what happens when someone sneaks into a football ground after hours and gets hurt, you've stumbled right into this topic, literally and legally. Occupier's liability is all about the responsibilities of people who control land or buildings, occupiers, towards anyone who enters their property. This area of law is split into two main rules. So, as you can see here, we have the Occupiers Liability Act 1957. Now, this deals with people who have permission to be on the property, so lawful visitors. And then we have the Occupiers Liability Act 1984, which covers people who don't have permission, so trespassers. So these laws basically answer questions of, how far must occupiers go to keep people safe? So let's now take a closer look at what is meant by the word occupier. The law doesn't really spell out exactly what an occupier is. There's no official job title, unfortunately. But the case Wheat versus Laken from 1966 tells us that it's basically anyone with enough control over the premises. That could be a business owner, a tenant, or even the manager of a student dormitory. And premises isn't just land or buildings, it covers things as weird as ladders, vehicles, bouncy castles at a fair, for example. So let's take a closer look at that 1957 Act about lawful visitors. So what does the law expect? So it says that occupiers must take reasonable care to keep lawful visitors safe while they're there for the reason they're allowed to be there. And this is called the common duty of care. So reasonable, well, that doesn't mean that everywhere has to be padded, it doesn't have to be like a padded room. It just means that it's not full of unexpected dangers lurking around every corner. And here's an interesting fact for you. If you visit a friend and while holding your brand new phone, you lose your balance on the stairs because of a wobbly banister, and you accidentally drop that new phone, well, occupier's liability could be in play. Let's take a closer look at warnings. When are they enough? So occupiers can fulfil their duty by giving warnings about dangers. But not just any old warning will do. There was the case of Ray versus Mars from 1990. There was a pit just inside a dark shed. And a sign saying danger wasn't enough because that threat was just too extreme. But in Staples versus West Dorset, there was no need to warn about slippery rocks by the sea. I mean, most people know wet rocks are slippery after all. So let's now look at types of lawful visitor. Who gets the red carpet? Well, invitees. So what is an invitee? It's basically people invited for a specific reason. So think of party guests or customers in a shop. Then you've got licensees. So these would be friends popping by for a chat. They're allowed, but they're not specifically invited for a business reason. Then we have contractual entrants. So these would be like hotel guests. You've paid, haven't you, for the right to enter. And then finally, the legal right of entry. So this could be utility workers, maybe people reading meters, or police with a warrant, for example. Let's take a look at children now. So there are special rules for children. Children are curious, aren't they? Sometimes dangerously so. And that's why Section 2(3)(a) says occupiers must make sure the property is safe for children of the age expected. So Glasgow Corporation versus Taylor from 1922 is a really classic example. A child was tragically poisoned by eating attractive berries in a public park. And the court said the occupier was responsible. The berries were basically like sweets for kids. But in Phipps versus Rochester Corporation from 1955, a young child fell into a trench. And the court held that parents shouldn't let very small children wander alone, so the occupier wasn't liable. Think of it as the, don't let your toddler roam free on a building site rule. What about visitors at work, professionals, independent contractors? So if someone's at your property to do their job, like an electrician or a chimney sweep, well, they're expected to protect themselves from risks related to their work. So Rolls versus Nathan in 1963 is a really sad but important example. 2 chimney sweeps died from carbon monoxide poisoning even after being warned. And the court said the occupier wasn't liable. The risk was part of their job. And then we've also got to consider independent contractors as well. So if you hire a contractor to fix something and it goes wrong, well, the occupier, again, isn't usually responsible if they chose the contractor wisely and checked their qualifications. So in Hazeldine versus Dawn Sun Limited, a lift repair went badly, but the occupier wasn't at fault because they had hired experts. Moving on now to the second act. So this is the 1984 Act, which really handles issues relating to trespassers. So how does the law treat trespassers? Well, before 1984, trespassers were basically on their own. In Addy versus Dumbreck from 1929, the court said occupiers only needed to avoid deliberately harming trespassers. Not exactly welcoming, but things did change in British Railways Board versus Harrington. And this is in 1972. A child was injured on the electrified railway tracks, and the court introduced a duty of common humanity, recognising trespassers, especially children, deserve some care. The Occupiers Liability Act 1984 now says that occupiers owe a duty to trespassers when 1. The occupier knows or should know about a danger on the property. 2. The occupier knows or should know that someone might come near the danger. And 3. The risk is one the occupier should protect people from. So if someone sneaks in and falls down an uncovered well that the occupier knew about, well, the law might step in there. Reasonable steps only. We don't have to babysit trespassers. So the occupier just has to take reasonable steps to avoid injury. In Ratcliffe versus McConnell, 1999, a student was injured diving into a pool after hours. But the risk was obvious and the court said no liability. He took his chances. Warnings and obvious dangers. Occupiers can warn trespassers, but the warning must be clear and suitable for the risk. Generally, there's no need to actually warn about really glaringly obvious dangers. So in Tomlinson versus Congleton, the court didn't blame the council when someone was injured diving into a lake. I mean, it was a lake, it was an obvious risk. Children? Well, as we've said, children do frankly rather weird things, don't they? Like climbing fire escapes for fun. And in Keown versus Coventry Healthcare NHS Trust, an 11-year-old was injured while climbing. And the court decided the injury was due to what the child was doing, not the building's condition. So, no liability. And there's a little table there for you to compare them side by side. You can pause that and take a closer look. Okay. So as you can see actually from this table, it's clear that the law gives more protection to lawful visitors. While trespassers get less protection, owners don't have to go out of their way for people who shouldn't be there. I think that's fair enough. But if an owner knows there's a real danger and someone might trespass, they must at least take basic steps to prevent injury. So let's consider some evaluation. Is it fair? Is the law fair? So strengths. Well, clear rules help keep both visitors and occupiers safe. And special attention to children and professionals matches what we expect in society. Dividing lawful visitors from trespassers, well, that seems fair enough, doesn't it? It creates a fair balance, no one size fits all. But there are some weaknesses too. What's reasonable? It's a bit vague perhaps. It's not always clear, and some judges actually come to different conclusions about what that means. Trespassers, especially children, don't get much protection, even though children don't always realise what's risky. And occupiers might not know exactly when their duty starts to be considered trespass. Okay. AO3 focus, balancing rights. Now, courts try to balance safety and personal responsibility. Lawful visitors get more protection, while trespassers are expected to accept the risks of breaking the rules. This strikes a balance between property rights, safety, and common sense. I mean, as fun as it sounds, you can't expect to break into the zoo at night and then sue because you fell into the penguin pool. Fair enough. Policy and reforms next. So where next? Codification perhaps, maybe simplify the language to reduce confusion, make the law more accessible to everyone and not just lawyers. Then we have ideas about corrective justice, so maybe focusing on fair compensation when occupiers are really at fault. Economic efficiency, something else to consider. Don't make occupiers insure against every silly or obvious risk. Let's not bankrupt the local park because someone slipped climbing a tree after all. And then we've got distributive justice. So consider more protection for vulnerable groups like maybe children or disabled trespassers. So conclusion, why does it matter? Well, occupiers' liability might sound a little dry, but it shapes the world around you. How safe that shopping centre is, whether warning signs pop up at the beach, or even whether you can recover damages if you trip over a tent peg at a festival. It's important to remember that at the heart of these laws is a simple idea: fairness, balancing responsibility between those who own the property and those who enter it. So thank you for watching, and next time you see a caution wet floor sign, you'll know exactly why it's there.